Hi, everyone. Welcome back to Leave It to Us. And we're really excited for today's episode. But first, Brycie, guess what?
What?
The Americans with Disabilities Act is 36.
Oh my gosh, I feel so unprepared.
Which is roughly our age, but that's neither here nor there.
I've personally been 36 for about 7 years.
Me too.
Okay, great time for a story time. The public is not yet aware, but will be after hundreds and perhaps thousands of you watch this episode. But every year on my birthday, I wear a tiara to celebrate. And it might be silly, but I love it more and more every year. And I'm just in a place where I feel like I need more opportunities to sport my birthday tiaras. So pretty sure I'm going to start busting these out on big legislative act birthdays. The possibilities are really endless because there's over 500 federal and state leave laws. So it starts with ADA, but who knows where it goes.
I mean, at this point, it's just going to be like a daily thing. I think there's nothing more fitting than wearing your tiara to celebrate the ADA. It's truly perfect.
And it's going to be a good episode. I can feel it.
As we were working on this episode, and this is one of my favorite things, we were realizing that we have a little bit of a history as a team of celebrating the ADA. So as you tune in, we are actually going to put up a throwback post of when we celebrated the ADA when it turned 30, which is also what I turned last year. I hope you're following along with my math. But in all things themed ADA today, that's what we're going to talk about. We're going to spend a little bit of time just kind of talking about an overview, sort of like 101 of the law. And we're going to talk a little bit about the fact that the law that you're managing today that was signed in 1990 is vastly different as a result of some of the amendments that were passed in 2008. So, Brycie, why don't you tell us a little bit about how we got here in the first place? Maybe a little history lesson, if you will.
Yeah. So the ADA was enacted in 1990 to perform a couple of different functions. And one, it prohibits employers from discriminating against employees with disabilities. And then two, and I'm sorry, I just missed a crucial component. Not only employees, but also applicants. Prohibits discrimination against employees and applicants. So we are obligated, our ADA obligations as employers kick in during the application stage. That's like a something that we miss sometimes. So I wanted to call that out instead of missing it entirely. The second prong of the Americans with Disabilities Act requires employers to provide reasonable accommodations to employees that will enable them to be able to perform the essential functions of their job. Those are the two primary intents and pieces of the ADA. So when the law was passed and cases started working their way through the legal process, what was happening was that there was so much emphasis in the courts on whether or not an employee was considered to have a disability that oftentimes the legal battle was never really about what employer did you do to try to help this employee? And did you act in good faith? Did you follow the interactive process? We just were not even getting that far in these legal cases. And that is really what created the impetus for the amendments that were passed in 2008. It really provided us with a much broader framework for what's considered a disability, especially taking out any mention of mitigating measures. So if, for example, I myself am legally blind, even with my glasses, but a lot of people are only legally blind without their glasses. And so pre-2008, the ADA would have said, you don't even have a disability because you have something that you're doing to fix it, or, to make it so that you've corrected the limitations that you will have otherwise experienced. And so, again, these cases were just dying on this person doesn't really have a disability, where the focus was meant to be on are employers acting in good faith to assist disabled employees and keep them in the workplace? And so in 2008, again, the definition of disability was broadened, and it was made very clear that going forward, the emphasis was going to shift in the courts to what did you do to try to lend a hand to your disabled employees? And now the kind of the first step of the ADA process, which is determining whether an individual has a disability under the ADA, is meant to be a very quick step in the process, and the bar is pretty low at this point. And so we're really looking at, a medical condition that affects one or more major life activities, limits the employee at work. So it's not so much about, are you disabled? It's now about, how can I help you?
I love it. And I moonlight as a lot of things in my life, but being a doctor is not one of them. So to a certain extent, I think that removing that burden from employers for determining if XYZ condition is actually a disability makes things a little bit easier. So I'm a fan. Well, let's talk a little bit about, to kick things off further, what are some things that we can request as part of the medical inquiry process, as Brycie mentioned, and what are some things that we should not request? So I'm going to give you just like a quick hitter list of what should be on your please ask for this employer. This is going to make your job a little bit easier when you're evaluating this. So first and foremost,
just even to set the stage here, one of the great tools that we as employers have in the ADA evaluative process is our ability to request medical documentation that helps us understand the need. And especially the restrictions and limitations of the employee. So like our friend, the FMLA, we have tools in being able to request medical certification under the ADA if we need help understanding an employee's restrictions and limitations. So we're going to walk through, like, what can we be asking an employee's healthcare provider to provide? And then I'm going to be going through, what do we need to steer away from?
Absolutely. And the only caveat I'd give to that too is we don't want to ask if the disability is obvious. So as a general rule. So for example, if we have an individual in a wheelchair, it's obvious to us that they're going to need some handicap accessible desks, restrooms, parking. Please don't ask someone to verify those needs for you if they're coming into your workplace in a wheelchair. But as a general rule, for all of those other conditions that aren't necessarily obvious in nature, you can ask, hey, is there a mental or physical impairment that's limiting a major life activity? Ask what job functions specifically the employee is unable to perform due to the disability. So get a little bit more targeted instead of just saying, what are the limitations or what can't the employee do? Be specific in asking what job functions is the employee unable to do? Get that duration. That is something that I feel is missing a lot. We coach a lot of our clients on. If it's temporary, get a start and end date. Don't allow a provider to just check a box that says temporary. Ask the provider to give you what workplace accommodations would enable the employee to perform the essential functions. This part of the conversation, I think, can be interactive, if you will, or collaborative with the employee, working together to get accommodations that's going to make them successful in the workplace. If you have an accommodation need, and this is a huge change from, what has progressed in the law from 1990 to now, or even 2008 to now, is leave as an accommodation. Leave as an accommodation is not something that employers, I'm being careful in choosing my words here, but it's not something that employers traditionally had to accommodate. It wasn't typically like, hey, I need an ergonomic keyboard, or I need a special stool, or I need extra breaks. It's only something that's become standard and really required to be evaluated as an accommodation in today's workplace. But if you do have an employee who needs leave as an accommodation, make sure that you're asking, hey, is leave the only viable accommodation? Is that the only thing that we can do for this individual? What is the start and end date of that leave? And I recommend having some check boxes on a form that are going to specify, is the leave need permanent or is it unknown? Because if we get specification from a provider that leave needs are permanent or unknown, there is a tremendous amount of case law employers to support you that that type of accommodation is likely not going to be reasonable. If you have an accommodation that's an extension of leave, gosh, this is so hard for many of you to navigate. You have your employees that we've had 3 different return dates, 6 different return dates. Sometimes it just feels like it's never ending. If you have an employee who's needing a leave accommodation extension, so a modification of that originally expected return date, ask the provider to explain the medical facts that have changed. Ask that medical provider to tell you, hey, why is this state that you're giving me now going to be more accurate than the last one? If the employee needs intermittent leave, some of the same information that we talked about with continuous. So get frequency and duration. The same information that you're going to be requesting for an intermittent FMLA claim, ask for it for ADA. Ask if there's any accommodations that would reduce the need for intermittent leave and what those are. And take it a step further. If those accommodations would reduce the need for intermittent leave, ask for an estimate of the percent of time off that would be reduced by it. I think my point is, or our point is, and I'm not even through the list yet, is some of these customizations and extra questions can feel like a lot of work. But at the end of the day, I think that they're going to save you some time in more thoroughly identifying what an employee's needs are and being able to make a decision without additional back and forth. I'm not saying there won't be back and forth. There most likely still will be. This is always really, really challenging. I mean, to this day, we have employers who are like, can I just say XYZ is not reasonable? No, you cannot. Under the law, we have to evaluate each request on a case-by-case basis. But those customizations are going to be key. If you have an employee who needs to work from home, ask a question to the provider if there's any issues related to commute. Because if you actually find out that there's commute issues related to a request to work from home, that's going to change the landscape of how you look at that. If the request is for like adjustments to performance. So let's say missed deadlines, which sidebar likely isn't reasonable. We don't have to lower our performance standards as part of an accommodation under the ADA, but ask for a medical opinion on how this medical condition impacts an employee's ability to meet deadlines or communicate when they're not able to meet a deadline. So really get specific there. That's going to be my please ask for this information list. Brycie, anything you'd add?
Just to say that what you're going to request from situation to situation will often vary. So it is, again, like ADA is so different than FMLA or like standard like leave entitlement based laws where we can have a very prescriptive, consistently run process. Our medical certifications can all look the same. Under the ADA, the whole way we get to a reasonable accommodation is by completing an individualized assessment of that employee's needs and what we can do at the time that need exists, and working through an interactive process. And the level at which you'll need to correspond and collaborate with an employee, with their manager, with any stakeholder, including the healthcare provider in that process, is going to vary from case to case. So it is common and expected that you may need to get more in the weeds and more creative with healthcare provider for employee A versus employee B, because employee B's need is much more obvious and the answer might be more clear. But with employee A, we may need to work with the stakeholders to get creative. And honestly, the more that happens and the more we can demonstrate and document that is happening, the easier it is for us as employers to show that we're acting in good faith and we're really doing our best to try to work with that employee. So for example, all of those components that Christine, you just shared around, hey, if somebody's requesting intermittent leave and FMLA is not in the picture, here's some of the boxes we should be including on that medical inquiry form. You may not need that for somebody who needs a continuous leave. So I'm a huge fan of, having templates and forms as part of your standard process. But in the ADA, there's room for, and I would recommend, the concept of being a little bit more flexible. And then
what we shouldn't request. Is that where you were going to go next?
Yeah, that leads us to just a couple of call outs that we have on what not to ask for in the medical inquiry process under the ADA. So we wanted to give a special shout out to states like California, where it is very clear that we cannot ask for diagnosis, for diagnostic medical information. And I would actually broaden that and challenge you all. I believe we can successfully navigate the interactive process and find workable solutions for employees without ever knowing what their diagnosis is in almost every circumstance. I think that our ADA evaluation is focused on us understanding the employees, first and foremost, their abilities. What are they capable of in the workplace? And then really, understanding their restrictions and limitations and how those restrictions and limitations impact their ability to perform their essential functions. I think we can get to all of that without knowing a medical diagnosis. Sometimes having that information is really handy because we can go to a super healthy site like the Job Accommodations Network has lists of possible accommodations by medical diagnosis, and it's super. It's just a fantastic resource. So there are it certainly can make it easier, but I don't think that it's necessary for us to be putting a diagnosis box on a medical inquiry form. And there are jurisdictions where we cannot do that. The other thing I wanted to say, and it's not so much we can't do this, but it's a challenge to some of us out there to reframe how we're approaching employees and their healthcare providers who are coming to us for help. If your ADA request form that the employee completes has a box for what can we serve you up for an accommodation today, or your medical inquiry form says, hey doctor, what accommodation does this person need? I would challenge you to reframe that and take the power back a little bit in that conversation, and just know it is our role as employers to troubleshoot what an effective accommodation might be. And it's also our role to make sure that we're bringing stakeholders in on that, including the employee, their manager, the healthcare provider, to make sure that we're getting their buy-in and their, that we're collaborating with them on what might be a helpful, successful accommodation. But ultimately, it's our job to find a reasonable accommodation. And I don't think that it's in our best interest to give that job to the employee or to their healthcare provider directly. I think that, we want to be the ones working through what's going to make the most sense for the business, what's going to enable the employee to perform the essential functions of the job. So maybe just like if you've got some of those questions in your employee request form or your medical inquiry form, and all of a sudden you're finding, 25% of our workforce wants the accommodation of not working Fridays, then it might help to think about reframing how the interactive process goes a little bit, and leading with, again, abilities, restrictions, and limitations, the impact to the ability to perform the essential functions, and then bringing our whole stakeholder team together to collaborate on possible accommodations.
I love it. And I like to, Brycie, you just inspired a thought. When we get information back from a provider, I'm trying to think of a good example here, where it's a little bit open-ended for employers to interpret, use that to your advantage. So let me give an example. If you have a request that comes forward that says employee needs to work from home 1 day a week, employer, you pick the day. So that's a situation where I say, identify a day, assuming it's reasonable for you, assuming the essential functions can be done at home, but identify a day that operationally will be a little bit better for you to manage. If that's, something that you feel is going to work better for you. Don't necessarily give the employee the opportunity. You have the opportunity to take control of some of that as well. So, all right.
Yeah, and I would even challenge that further. Like that's the healthcare provider dictating or attempting to dictate what the accommodation should be.
Yeah.
But do we understand where that's coming from and what that's trying to solve for? And I mean, even if you get something from the healthcare provider that says this person just simply cannot work Fridays, I think that's just an excellent opportunity to collaborate with that healthcare provider and say, that's our heaviest business operation day. And we would like to explore with you, like why, like we want to get curious and understand what is it about Friday? And it's so crucial to the success of our business that we have a certain level of support on this day. Is there an opportunity for us to do something on a different day? Or again, like there are areas where we can collaborate in good faith to get to, something that's going to work for everyone.
Well, happy birthday, ADA.
Happy birthday,
I can't wait to
ADA.
celebrate 40. We'll have to get a cake next time. And that's the same year we turn 38. So it'll be like, it's girl math here, but it'll be really significant for us to ring that one in. Thanks for tuning in, everyone.
Thank you.
The information provided in this podcast is for general information and education purposes only. It's not intended to be and should not be construed as legal, financial, or human resources advice. While we strive to provide accurate and up-to-date information, laws and policies regarding leave management vary by jurisdiction and may change over time. Listeners should consult with a qualified attorney, HR professional, or relevant expert for advice specific to their situation. The views and opinions expressed by the hosts and guests are their own and do not necessarily reflect those of their employers or any affiliated organizations.